If you just received the cease and desist, what are the next steps that you should be taking to protect yourself legally when it comes to dealing with these cease and desists? Today, we're talking to everybody's favorite IP and entertainment lawyer, Tony, to learn more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called the IP Professor that is dedicated to all things intellectual property.
Tony, we've been talking about cease and desist here on the platform. And in our last episode, we talked about what to do if you're a company sending a cease and desist. Today, I want to talk about what happens if you're the one on the receiving end of things. So, we're going to assume the first thing that we should not be doing is panicking. What should we be doing instead?
Yeah, so I always say it, and I'll say it till I'm blue in the face. I think not panicking is a very, very important first step. I think going into this process with a very cool demeanor is going to be really, really important because I think fact gathering is essentially going to be the next step towards assessing what to do when you get a cease and desist. So when you get your cease and desist letter, obviously, I think you should obviously read to see what the subject of the cease and desist is. But if you're not understanding any shred of what you're being accused of, that's when you go to a lawyer and you ask for advice. So at the end of the day, it's all going to boil down to what the language of the cease and desist says. Normally, the way cease and desists are drafted, whether a copyright or a trademark or any other aspect of IP has been infringed on, it's going to lay out who is enforcing these rights, aka who is the copyright owner or the trademark owner or other IP owner. What are they alleging? Are they alleging an infringement in part or in whole? They may lay out certain information about ownership as a la registration numbers. And then what they're going to do is they're going to lay out what the actual accusation was. What did you do that warranted the cease and desist letter? So let's say you got a cease and desist. Let me paint a better scenario. Let's say that you're a meme account, and let's say that you posted an entire TikTok video. You didn't use it in the context of fair use. Let's argue for in a neutral manner. You posted the entirety of a video that belonged to somebody else on your meme page. Now the question becomes, is that what's being alleged in the cease and desist? If they're saying, if the person that's claiming infringement says that video that you posted on your TikTok page or your Instagram page, that's my video, I'm enforcing these rights, this is copyright infringement, then you have to basically now, as the recipient of that cease and desist, go back to see, did I actually in fact infringe on that? Looking at your paper trail, did you even dare to ask for permission? If you didn't ask for permission, did you think that maybe fair use was an option? If you thought fair use was an option, did you even talk to a lawyer about that? These are the kinds of questions that you really need to ask yourself sincerely when you get these types of cease and desists. And listen, I think going back to the first step about not freaking out, I think that's really important because I've seen it on the receiving end in my shoes where I work my day to day where we get cease and desist and we're alleged to have infringed on copyright, but I think a simple paper trail via emails and looking at previous license agreements and so on will lead us to at least assert, okay, this was a misunderstanding because this actually wasn't the heart of the infringement. It was something else. Or we could verify that we had asserted a fair use defense or something like that. So there's no right or wrong answer. There's no cookie cutter model that's always going to apply to every single person who gets a cease and desist. But the fact gathering process is so paramount to this whole thing. So making sure that you cross check every last email that you have possibly on that relates to this infringement, that you have potentially anything that would help lead you to properly answer the cease and desist is going to be really important. And then, of course, I think going back to the heart of this whole thing, going to a lawyer and sharing that information and working with them to figure out what to do next is going to be important. I'll say this: cease and desist, as I've said before, operate as mitigation tactics. And so when you get a cease and desist, unless you really want to fight it tooth and nail and go hardcore, take it all the way to court, listen, God bless you, all the power to you. But I learned this in law school. Ask any other lawyer on the face of the earth. 90% of cases end in a settlement. It is probably the most cost-effective measure to just settle and call it a day. And I'm talking about settlement if you legitimately infringed on somebody's copyright or trademark or some other IP.
Yeah.
If you didn't and you have a legitimate argument to make, maybe you could fight it out a little bit more. But if you show some type of compelling proof that doesn't that some type of compelling proof of non-infringement, maybe they still want a settlement. At least you've moved the needle from, let's say, a higher dollar amount to something that's within your budget and something that the other party will be happy with. That's all going to depend on, how hostile and how, adversarial the other party is, of course. But, negotiations are going to be kind of the name of the game when you're trying to close out this whole cease and desist phase. So I would say that that's what I would do if I were on the receiving end of getting a cease and desist letter.
So let's say that a company gets a cease and desist letter. Should they immediately take action and remove it or private it, hide the content that they've posted, or should they pause and consult a lawyer first? Is there merit in waiting a moment before responding and taking action?
Yes, and I know that, and I agree with that entirely. Going to a lawyer first before doing anything is going to be the great way to go for a lot of reasons. But one, not that it would necessarily show an admission of guilt, but it's not a good look if you're going practically scouring throughout your entire page or scouring through wherever the infringing use is and taking it all down immediately. I think internally discussing it with the lawyer first to strategize, like, you basically think of the lawyer as almost like your PR crisis manager. They're not in PR, but they're
Enough.
certainly the business of crisis management. So, they're going to help give you the best roadmap that's not going to make you look in a bad light. So odds are that could probably involve leaving the content up first, leaving the infringing use up, talking to the other attorney first, fishing some details, having a little bit of a candid conversation, and then essentially once that phase is kind of phased out, then maybe the next step is to, as part of the settlement, to take down the infringing uses, to not use it any further, or maybe to pursue a retroactive license. There could be some good that could come out of some type of use of infringement, where it could actually still allow you to use that copyrighted material or that other IP, but you would have to properly license, get the proper permissions. That is a thing that commonly happens as well. It doesn't necessarily have to be an injunction where you're enjoined from using that material in the future. So there are umpteen ways of resolving it, but I think taking it down right from the get-go might not be the most sound strategy. Unless you feel otherwise, and that's your choice, I think that might not be the best way to go.
Now, let's say that we know for a fact we did something wrong, and when we get hit with that cease and desist, what is the best next step for us to take? Is it to go and see a lawyer, or is it just to immediately take it down and apologize profusely?
I think that that's relative to the person, but I'm of the mindset that if you talk to the lawyer, they're probably going to tell you the exact same thing I would say, which is to take it down, say I'm sorry, and you hope to God that the person that is on the other side is a very forgiving and gracious person, because there are people that are very volatile and say, I could care less if you took it down. I'm still going to sue you and file a copyright infringement claim against you. Or they may demand some type of payment in the cease and desist, regardless of whether you take it down or honor the request or not. So there are a lot of factors that come into play, and no fact pattern is equal in each situation of a cease and desist. But I think consulting with a lawyer will help give you the best roadmap. And more importantly, especially if you've never, ever, ever received a cease and desist. Now, if you're a C&D veteran, great. Then you know exactly what's coming. But if you've been, like if you literally feel like Mr. Krabs in that meme where he's like freaking out and it's all blurry around him, then that's when that's your cue to go to the lawyer and ask for some counsel, because that's what they're about. That's the whole point of a lawyer. They're hired to advocate on behalf of their clients. So they're going to give you the best counsel and advice for that reason.
So it's incredibly important to make sure that you take a deep breath when you get a cease and desist. Go talk to your lawyer, go find a lawyer, go have a conversation and work with them to take those next steps to make sure you are staying as financially unburdened as possible when it comes to dealing with these cease and desists. And if you've got further questions on any of this, go ahead and drop those down below. And as always, you can find Tony on social media, where he is dropping such incredibly smart knowledge about the legal field and how to stay legally protected as an entrepreneur. So, Tony, where can everybody find you online?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my brand new entertainment law podcast called End Scene on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Hit the subscribe and notification bell as we're dropping daily videos to help you navigate the world of social media, building your online business, and making sure you're staying legally protected in your entrepreneurial endeavors. Tony's coming back for more episodes, so drop any further questions you have down below, and we'll see you in our daily episodes, making sure that you are making this your most profitable year ever.